Okay, take seats, please. Let's start. Well, first of all, on behalf of 39 Essex Chambers, welcome everyone to this seminar on arbitration and Asia opportunities and challenges. This is a subject of particular interest to this Chambers, with members living and working in Singapore and Malaysia, and a focus on international arbitration with Asia connections. And our CEO, Asia, Adam Al-Busan, is in London and here today. So as we emerge from the unsociable days of COVID, it's great to be able to meet, at least still in part, in person, but with the advantage of being joined by colleagues abroad. The LCIA had a spring reception the other day. I don't know whether you went to it, but it was extremely well attended. And it was extraordinary after the last couple of years to see people that you'd worked with virtually in arbitrations. It was a bit like seeing someone off the television that you recognize. I remember. And then they're either much taller than you thought they were, or smaller than you thought they were, because you only ever got to know their face. But it felt like an arbitration spring, and let's hope that we can all do more of this. It's also a good time to take stock of developments in arbitration in Asia, with rule innovations in SIAC and the HKIAC, a prospective new arbitration law in China, and the welcome news that Sundra Raju is back at the helm of AIAC in Kuala Lumpur. We're particularly fortunate to have guest speakers and contributors from outside chambers. We have Kevin Nash, Registrar of SIAC. Thank you so much, Kevin. I know that it's midnight for you, whereas with Swee, it's comfortably in the middle of the morning. So thank you very much for joining us at this unsociable time. We have colleagues Matthew Townsend and Lucy Winnington Ingram from Reed Smith, Sherina Petit and Alfred Wu from Norton Rose Fulbright, and Mrinal Jain from Secretariat. So, true to his reputation for excellence and innovation in international arbitration, this seminar is the brainchild of Matthew Townsend, together with our colleague Swee. Now, I first met Matthew a number of years ago when he was living and working in Beijing as something of a pioneer. And I think he's been continued that pioneering approach if one looks at his CV and the accolades. And he's now a partner at Reed Smith in Hong Kong. He's just flown in from Hong Kong this morning, so we've been plying him with coffee as far as possible. So the evening is split into two sessions, and Matthew's going to chair the first session. So let me please hand over to Matthew. Thank you very much.
Okay, thank you very much. If anybody has any audio issues on the Zoom, please do let me know. Actually, possibly that question was poorly phrased. Okay, so the topic of this first panel is shorter and sweeter, which is probably quite apt for those of you who are here on a rainy afternoon. Innovation in Asia-related arbitration procedures. So we're going to keep it to 45 minutes or less. And I'm absolutely delighted to be joined by an extremely experienced and talented panel. On the screen, you can see Kevin Nash, who, as mentioned, is the Registrar of the SIAC, the Singapore International Arbitration Commission, and he leads the SIAC Secretariat in the provision of case management services, and I'm told that he's overseen more than 1,000 cases. And Kevin also leads, pertinently for the purposes of today's talk, the SIAC Secretariat in the drafting of the 7th edition of the SIC rules, and he's also recognized as a prominent arbitration practitioner by directories such as Who's Who Legal. He's qualified as a barrister and solicitor with the Law Society of Upper Canada. Moving along the table left to right, to my left is Sherina Petit, who is an international arbitration lawyer and partner at Norton Fulbright in London, where she leads the firm's international arbitration practice across Asia, Europe, and the Middle East, and also, again, personally for today's seminar, leads the firm's India practice. Sherina has a wide range of experience in international arbitration, particularly related to India across a broad range of industries, and also has considerable experience in investor-state dispute settlement, alternative dispute resolution, and litigation. To Sherina's left is Grace Cheng, who is an English barrister at 39 Essex Chambers, our gracious host for today. And interestingly, for the purposes of today, she is also a Hong Kong qualified solicitor and a registered foreign lawyer at the Singapore International Commercial Court. And in addition to her practice as counsel, Grace is a sought-after arbitrator and adjudicator and has received appointments in relation to a diverse range of areas and involving a diverse range of governing laws, including the laws of Hong Kong, England and Wales, and Singapore. And last but not least, to Grace's left is Johan, who is a specialist commercial barrister at 39 Essex Chambers. Johan practices across the full spectrum of commercial and construction disputes. He has appeared in the Court of Appeal, the High Court, and before international arbitration tribunals, and he's ranked in the Legal 500 for this year, 2023, as a rising star. And previously, I didn't know this, has practiced as a solicitor in a previous life at Cleary Gottlieb Steen and Hamilton LLP, where he focused on international arbitration. So, as I've mentioned, possibly you have already forgotten, the topic of today is innovation in Asia-related arbitration procedures. And certainly from my point of view, this brings to bear one of the vaunted advantages of international arbitration. And as arbitration practitioners, we're used to rolling these out, independence, impartiality, cross-border enforceability. And among those attributes is, of course, flexibility. But not only is arbitration a creature of contract, so that the parties are at liberty to set their own procedures, but under the rules of international arbitration centers, the arbitrators also have considerable freedom in their case management powers. But in addition to being one of the most vaunted attributes of international arbitration, flexibility, I would say, is also one of its most underutilized attributes. Certainly in the industries in which I'm familiar with, technology and Web3, for instance, the users are not always, the users are sometimes good, arbitration could be a little bit more flexible for their tastes. And in China as well, the involvement of a whole group of lawyers and users who come from a different legal tradition can also lead to tensions in the international arbitration procedures. So let's talk first about where the drivers of innovation come from in Asia, and perhaps about the institutions. So if I could turn to Sherina first, let's take stock of the arbitration landscape in Asia. From your perspective, how are you seeing institutions drive innovation in the area?
So I think when you look at Asia, the first thing is the biggest impact has been, well, not just on Asia, but on the world, has been the pandemic. And we all learned a new way for business to be conducted, particularly with the enforced lockdown. And the legal sector was no different. It saw the rise of legal tech. And we've seen a rise of that, particularly in India, and I'll be speaking about that a little bit later on, about how India has adapted with the rise of legal tech. But at the heart of India, when you look at it, is actually a very large, young, dynamic population. And my fantastic training who's here, Charlotte, did some research on the population. India today is home to 1.37 billion people, but 65% of those are actually under the age of 35. And so while most other populous countries, such as China, are facing the challenges of a shrinking population, what India actually conversely is seeing is that it is the opposite, because it has the largest number of millennials and Gen Z on the planet. And what does that mean? If you've got a young generation coming up and you've got legal tech, that has to go hand in hand together. When you look at arbitration in India, and you can see the frustration now of the younger generation coming up, because India basically used to look at ad hoc arbitration because they thought it was cheap, cheerful, budget friendly, and flexible. You had the LCIA that came into India. It was the first international arbitration institution that came into India, and it thought it would change the landscape of India. But unfortunately, after 6 years in India, it's closed its doors in 2016. And that was because it came out with a new set of rules tailored to India, as well as a fee structure, which it thought might work. But it didn't work, because what happened is that the Indians wanted the world famous arbitrators on their disputes sitting as arbitrators, and the arbitrators didn't want to earn the pennies of what the LCI had as part of its fee structure. So that didn't work. But it also gave rise to India thinking, well, it needed to have more institutional arbitration. And ad hoc arbitration wasn't working because it led to delays. It led to really badly drafted awards by people who frankly weren't qualified to write the awards probably. And an unprofessional arbitration background. With that, you had the rise of the Mumbai International Arbitration Centre, which was established in October 2016. And that is really professionally run. It's more a domestic centre, but it has its own set of rules and actually has a very good centre, sort of modelled on Maxwell Chambers. And more recently, you have the rise of the India International Arbitration Centre, which was formerly the New Delhi International Arbitration Centre, which is India's first statutory international arbitration centre, and therefore is of national importance because it has the teeth of the Supreme Court and the courts. One of the primary functions of this centre is actually to facilitate a panel of people who are going to select arbitrators for arbitrations under this institution. And last week I was asked to be on that panel to help with the selection. So I think they are looking beyond just the retired judges that you normally saw dominating the Indian scene, and looking more internationally to actually make it sort of a world-class centre.
Thank you very much indeed, Sherina, for that insight into India. I wonder if we cast the net a little bit wider and look at the impact of new arbitration centres elsewhere. Is that something that you're seeing drive innovation in arbitration? And I look here, perhaps Kevin and Grace, if either of you have anything to add.
I'll start. Thanks very much for having me. I'm sorry that I can't be there in person. I can say, however, that we certainly see a lot of 39 Essex, Norton Rose, Reed Smith in Singapore. And I think the last time that I saw all of our panelists, these were in exotic ports of call in Asia. I think what the Asian centers have really done is been at the front of the curve of innovation. I think that there, at one time, maybe even 10 years ago, there were maybe 5 centers on the continent, certainly LCIA at the front of the pack of those centers. And most of the disputes, even the Asian disputes, were moving up to the continent or to London. And so what the Asian centers had to do is be a bit more agile, nimble, to say that we can give that same gold class case management, but we're going to do it even faster and in a more cost-effective way. And for a user of arbitration, this is actually a really good thing. If you look at the 2021 Queen Mary survey, that was really an announcement of Asian arbitration. To have all of Singapore, Hong Kong, Shanghai, Beijing, all ranked among the top 10 seats of arbitration. And if I look across the Asian map and I think of all the centers where disputes could actually go, of course, Datuk Sundararaja back at AIAC, MCIA, all of the Indian centers, SIAC, HKIAC, KCAB, there's really a lot of choice. And if you look at why users started choosing these centers, in addition to the factors that I enumerated, the innovation. So I think it was very big for SIAC in 2010, introducing the expedited procedure and emergency arbitration, and more relevantly, putting the enforceability of emergency arbitrator orders and awards in the Singapore legislation. HKIAC is that expedited procedure, fast track proceedings, concurrent proceedings, the interim arrangement with Hong Kong, all very usable, chunky things for users, KCAB, the Seoul protocol. So that's what's happening in Asia. And I really do think that it is an exciting thing. Certainly those Asian disputes are still going up to London, and that's probably always going to happen. But it's nice to see that these Asian institutions have really become global institutions that serve a global user base.
Thank you, Kevin. And Kevin mentioned the Queen Mary White and Case survey, which of course many of the audience will be familiar with. But of course now there's also the Sidra survey run by the Singapore Management University. And that does shine light on the Asian market and shows how important the Asian market increasingly is becoming. And of course, when we look at innovation and arbitration, we can't look at arbitration in isolation. Of course, in Asia, there's a lot of innovation happening in the disputes resolution market as a whole. If we look in recent years, there has been a proliferation in the rise of international commercial courts. And if we look at the Singapore International Commercial Courts, the SICC, for example, we can see how innovative this initiative has been. Amongst the international judges, many of these judges come from both common law and also civil law regimes. In certain offshore cases, parties are able to have foreign counsel representing them. And we can also see the wide scope, the very wide jurisdiction that the SICC has, to the extent that in certain cases, they have jurisdiction over certain cases that have no connection with Singapore. And in those certain cases, the courts have a wider, they have more procedural flexibility. Some of these initiatives have been termed arbitration in litigation. And although they weren't set up with the purpose of competing with arbitration, rather to complement arbitration. But because some of these initiatives have been set up to deal with some of the drawbacks or some challenges faced by arbitration. Back in 2016, some of you may be aware of the debates that was triggered, that all started with Lord Thomas's speech in 2016 Bickle debates, where there were then debates as to whether arbitration had become a victim of its own success and was stifling the development of common law. And so we can see with the rise of some of these initiatives with the international commercial courts, we can see how this will and is very likely to trigger innovation in arbitration, given the rise and the innovations in some of these other areas of dispute resolution.
Yeah, thank you. So yeah, interesting. The institutions feeding off each other and leading to innovation in procedures. Sticking with institutions before we move on to other topics, one of the innovative procedures that we were mentioned earlier was early determination. Now, of course, early determinations or dispositive motions, as they're known in the United States, have been a fixture of US court proceedings. for some time, but they were only introduced into the arbitration rules of different institutions in the last, I guess, decade or so. And certainly into the SIC rules and the HKIC rules. So I'd be interested in Kevin's perspective on how these new procedures, fairly new from our point of view, procedures have borne out in practice.
Thanks, Matthew. Partly because this seminar is predicated on speed, I'll give a short answer that these have been very useful. And it's kind of interesting when you see how it's developed, because everyone would agree that tribunals possess these powers inherently, but it wasn't really written down anywhere except in ICSID, so it's being used in investment arbitration, and then I suppose in the JAMS rules as well. And if you follow the travaux préparatoires of the SIC rules, when we put out our public consultation draft on the SIC rules 2016, it didn't have our early dismissal of claims and defenses. So it's something that we discussed with the SIC court extensively. And what we were trying to look at there is how can we make this work across the proceedings? And so I said when we were talking earlier that our rule actually suffers from somewhat unfortunate nomenclature in that it doesn't necessarily have to be early in the proceedings. So early dismissal of claims and defenses, I think the innovation for SIC there was including defenses as well. It was codifying it in the rules, perhaps to give tribunals a bit more courage, and also to understand that these arbitration awards are not always going to leading jurisdictions for enforcement. We have to think about enforcement in that very far away enforcement court. Is it going to help to have it written down in the rules? We think that it is. Now, every institution is doing it a bit differently with these inherent powers that tribunals possess. So you see the HKIC early determination procedure, you've got a summary procedure at the Stockholm Chamber of Commerce, but all of these is to give tribunals, or at least some of these, a bit more procedural discretion. So from an early dismissal standpoint, we are looking at claims or defenses that are manifestly outside the jurisdiction of the tribunal or manifestly without legal merit. We did it by way of a two-stage test because we didn't have the 30-day timeline. So technically this could be raised later in the proceedings. And from our standpoint, when we were mooting this internally, and same thing that we've been talking about in Incitral Working Group 2, we just wanted to make sure that it wouldn't result in a trial within a trial. There's always that danger if you give lawyers too many tools, it may not achieve the ends that you want. So we want this to be available for appropriate cases, but not to end up protracting the proceedings. And we've even had early dismissal within the confines of an expedited procedure. So you've got 6 months for the entire proceedings and then early dismissal within those proceedings, and that's proven effective in a few cases.
So I wonder if anyone else on the panel has any views on whether these kind of procedures will give, in your view, courage to practitioners, bearing in mind, the concerns that we've seen about, due process paranoia, when sitting as arbitrator, not wishing to do anything which might give an enforcing court an opportunity to set you aside, or to refuse enforcement, or your court to set you aside. Are there any comments on that?
Well, Matthew, my only comment to that is the UK Law Commission last year launched a review of the Arbitration Act 1996, and that was very concerned, that was interest that was raised by the Law Commission in that the legislation does have powers. So I think it's likely that a lot of tribunals do have powers to make use of summary procedures, but whether they actually do so in practice is a different question, given that this isn't something that's been explicitly spelled out in the legislation. So there is a worry that tribunals may have this concern that if they do make use of the summary procedures, then the awards may be challenged for serious irregularity if this isn't something that is expressly spelled out in the legislation.
And I mean, Kevin, is there anything you would, having seen these play out in practice, are there any points you make in that regard?
On how they're working in practice?
On how they work in practice, yeah.
Yeah, I think that one thing that I like about early dismissal, early determination is that I think that it does have a vetting effect on unmeritorious claims. So if you have, so now it's not unusual, say in a response to a notice of arbitration, a respondent might say, we intend to apply for the early dismissal of the claimant's claim. So I think that it does prevent or say a claimant or a respondent from potentially abusive process, knowing that these provisions exist and these claims can be dealt with at an early stage. And I also look at how these procedures can be packaged together. So say if you're looking at the obstructionist respondent that is going to file counterclaims that are squarely outside the four corners of the arbitration agreement, maybe not paying their share of the deposits, there are provisions to have the respondent an award for the respondent to pay on the deposits to strike out those counterclaims. So I think that the way provisions under any sets of institutional rules can be combined is also effective.
Thank you very much. There are, of course, other provisions within arbitration rules, such as expedited procedures, which we've already touched upon, which we can discuss at greater length if there's time. But perhaps for now, we can move away from the institutions and move towards the topic of technological innovation. And there's obviously, as everyone here will be aware, that technological innovation, particularly in AI, is a very hot topic at the moment. And AI for some time has been vaunted as not only a tool for counsel, but also potentially a mechanism for making determinations itself. I know that this is an area that Johan is interested in, so perhaps you could give us your insight into the topic.
Yeah, sure. I get very excited about AI because I really think it's changing the world around us in so many ways, which already happened, that are happening, or happen in the future. And when I talk about AI, what I really mean at a very basic level is computer systems performing tasks normally requiring human intelligence. And it's important that one appreciates that AI lies on a spectrum. You have what I call low intelligence AI, medium and high intelligence AI. When one looks at high intelligence AI, of a machine which can independently think and make decisions originally, I don't think we're quite there yet, but certainly in the lower spectrum of AI, there's a lot that it can and has done to help arbitration and the legal industry more broadly. So it can help, for example, with automation, with more accurate and efficient legal research. It can be automation in helping in arbitration, helping users select suitable experts, suitable counsel, suitable nominees for arbitrators. And I think when we put it into words that we're familiar with, we realize we use AI all the time. So we have e-discovery, we have predictive coding that we use. In London, Allen & Overy now uses an in-house ChatGPT style platform. So their own lawyers have this recourse where they have a tool they use in-house, can help with contract analysis, due diligence, regulatory compliance, and the like. Allen & Overy is very keen to emphasize that it's not a replacement for lawyers. It doesn't reduce billable time. Of course, they'll say that, but of course it's helpful because it can be a shortcut which you can get to the nub of the matter, and a human can then review it, further refine it, and the like. I'm sure that many of you in the audience are familiar with arbitrator intelligence. So you can pay for reports that automates and scrapes together data from publicly available reports and questionnaires, and it produces a very deep insight into potential nominee arbitrators. We're looking at reports that can tell you a nominee's track record regarding document production requests, regarding the length of proceedings, regarding how case management decisions, regarding questions that the arbitrator asked at hearings. You can infer from there how the arbitrator thinks in a certain way or leans in a certain way, regarding the reasoning and awards and the like. And all of these things are to some degree on that spectrum, the use of AI in arbitration and in the law more broadly. When one starts going towards slightly higher end of the spectrum, you can start thinking about AI as a tool for outcome prediction. People get very excited about that, and it has been used in or trialed in more low-value disputes, but do query to what extent that will take off in higher value international arbitration. In terms of the advantages and disadvantages, I think the advantages are are quite obvious. Increased accuracy, potential for increased accuracy, increased efficiency, cost savings. But there are a lot of risks that come with it too. You have to risk that with due process concerns, you have a machine that runs the tasks you expect human input for. There are security risks in how the AI is coded and produces its output. And I think at some level, there's a concern as well that if AI learns by seeing what humans have done in the past, then they may bring with it all the prejudices and biases that humans in the past have. And those are things that I think one has to balance in managing this beast. It can be incredibly powerful, but there are risks involved. So in a nutshell, I think it's fair to say that there's a lot of potential. The arbitration community has embraced many aspects of AI, but approaching it with some caution.
Yeah, certainly the prospect of using an API to input thousands of hundreds of documents or thousands of documents, and then obtain from that a nice precise chronology or something like that, which could then be tailored on individual review, is something very attractive to me for obvious reasons. But I'm interested in Sherina's view, because I know that AI in legal tech has been pioneered in India, and I'd be interested in your views on that.
Yes, I mean, and I know time is short, so I'm going to race through this answer, Matthew. But what it has been tried in India is actually, so India, we used to have the method of transcription in India was very archaic, and it still continues. So you'd have a typist who'd be there typing away, probably about, the ones who'd get paid a lot would be the ones who type at 180 to 200 words per minute. And that still happens in most of the courts. But there has been a trial which the Supreme Court is at the moment looking at, which is a tool called TERES, TERES, which is technology-enabled resolution. And this was brought about by two brothers. One was ex-Herbert Smith associate who went back to India, and the other was his brother, who's an engineer. And they created this platform, which is effectively going to transcribe all hearings. And it brings about quick transcription, but also fairness and transparency. Because otherwise, with the typist sort of method, you didn't have transparency because no one knew what was said and what was actually typed out. So this is what the Supreme Court in India is currently trialing out. And at the moment, the trial is limited to constitutional crisis cases. But if that works, it's going to be churned out to the entire country. Last month, I was at a conference which was organized by the Supreme Court judges for the Delhi Arbitration Week conference, which is sort of the first time really the Supreme Court sort of welcomed the arbitration community in there. The judges were there, all of them meeting the arbitration practitioners internationally as well as domestic. And the entire conference was actually transcribed through TERES, and it was absolutely seamless and fantastic. So it looks like it's going to work. And if it does, that is going to change the landscape of India.
Thank you very much. Any other points on AI?
Yeah, and so again, as I said at the beginning of the assembly, when we're looking at innovation in arbitration, it's also worth looking at innovation in other areas of dispute resolution. In China, for example, there's been the rise of the internet courts, and also initiatives such that claimants can issue a claim via WeChat. So that's a social media platform like WhatsApp that we have here. But by using this platform on WeChat, it's very easy for claimants to issue a claim, and then documents are fed in by use of this platform, and then you have these hologram judges, which would then issue a decision. And so again, it's interesting to see whether such innovations in other spaces of dispute resolution will feed through to arbitration, leading to further innovation there.
Yeah, and I should also say that the Chinese courts, as I understand it, are also pioneers of using blockchain technology, the immutable characteristics of blockchain technology as a way to preserve and record evidence. I have to say I haven't fully grasped the technical details behind it, but certainly it's pretty innovative. So we We're approaching the end of this first session, and I know that some of our panelists have to take flights. But since we've covered the institutions and the technology, it seems that we should also cover the users of arbitration. And certainly as I mentioned before, having worked in mainland China, when you fold in a whole new community and a whole new legal tradition into arbitration processes, it's a real stress test of the existing arbitration procedures and a source of innovation. So that brings us to the topic of diversity. And I kind of open, since this is our final point, I'd open this question up to the tribunal to the panel. How, that's my jet lag catching up with me. How do you see diversity? What are your views on diversity as a source of innovation, but also just in general, what interesting diversity initiatives are you seeing?
Sure. So we can see we've spoken about the rise of arbitral institutions, and I think what's interesting is with some of these institutions, if we look at one of them in particular, the BAIAC, Beihai Asia International Arbitration Commission in Singapore, for example, what they have, you see on their website, is when they talk about how they select arbitrators, one of the things that they mention here is, as well as gender, geographical diversity, they also mention generational diversity and people inclusivity. And so we can see how with certain institutions, there is more of a focus on bringing in more junior arbitrators or people from certain backgrounds. So rather than just your usual big names, for example, we can see how certain institutions are starting to have this focus on this issue of diversity.
Yeah, I think diversity is something which the legal industry as a whole, the arbitral community as a whole, has really embraced, especially in the last 10 years. And we see diversity in a much richer form as originally perceived. As Grace mentioned, it's generational diversity. We have gender, we have practitioners from civil and common law jurisdictions, we have practitioners who really come from different backgrounds. And I think a lot of heart in that, because I think it recognizes and accepts now as received wisdom the case that diversity is a good thing, because it really brings different perspectives. And in coming to a decision which is legitimate, a decision which incorporates and takes into account all the different perspectives, it adds strength and resilience to the arbitration system. I think that's something that all of us can be very proud about.
Thank you. And Kevin, from the SIAC's point of view, do you have any closing comments on diversity?
Yeah, I would sign on to the intervention. Is the reason that why we want to promote diversity is because of our diverse user base. The appointment of arbitrators needs to match the diverse user base. I look at SIAC. SIAC has had parties from more than 110 jurisdictions in the past 5 years. We want the arbitrators to be reflective of this global spread of cases. And I think for us, the results have been very good. 2023 arbitration is much different than 2020, much different than 2010. We have had very good results appointing arbitrators with generational diversity. I did a quick check. I think we have arbitrators from 29 to 90 sitting in SIAC arbitrations, certainly visible and non-visible diverse characteristics. But the metric that we've really found is that it makes for better arbitrations. It makes for better decisions. And this particularly matters to SIAC because, of course, alongside ICC, we do the scrutiny of awards. And from an institutional standpoint, we feel like it's our mandate to identify new talent from different areas. And if I look around at some of the real rising stars in arbitration, a lot of them got their first appointment from SIAC. So we take this very seriously, developing that next generation of arbitrators.
Thank you very much. So the closing point, I think, will go to Sherina.
Yeah. I mean, what I've seen on diversity, I thought the pledge has been fantastic for diversity. That's a pledge for equal representation of women in arbitration. We launched that in India in 2018. So I'm on the main steering committee and also the chair of India committee. And that has been hugely beneficial because there wasn't really a movement to bring together the women who are, the diverse women in India who actually all practiced arbitration. And they had no idea about each other until we brought the pledge together. And last month, I launched the India Promise, which is to actually see more diversity of Indians sitting as arbitrators. And that was at an LCI roadshow. But I think diversity generally, the pledge has been, as I said, I thought the pledge generally has been a great movement. We've heard from Kevin about the SIC. In 2022, the ICC received the Equal Representation Award at the GAR as the most recognizing sort of the ICC's efforts in promoting gender diversity. And Abhinav over here, who's sitting here, he was at the ICC, and I can say he was a big promoter of diversity when he was at the ICC for India. And the LCIA court today is also one of the key driving forces of diversity, selecting about 47% of all its appointments being women. So I think all of that just shows how the arbitration landscape has really changed over, say, the last 7 to 8 years.
Well, thank you very much indeed. As time has run out on us, I'd like to thank Kevin, Sherina, Grace, and Johan very much for your participation in this seminar. I've certainly learned a lot. We've kept it fairly short and fairly sweet. So thank you very much indeed.
Thank you, everyone.
Thank you very much, Kevin.
Thanks, Adrian. See you. Have a good day.
Okay. Sherina, you're off to Barcelona, right?
I am.
That's
So is
well.
that Alfred?
And Alfred's going to join you,
Yes, well, we're going to meet.
but he has a job to do first. Right, please come and sit at the table. Okay, well, Matthew, thank you. That was a really excellent session, managed very efficiently. So this session, well, it's labeled Future Trends in Arbitration Involving Asian-Related Infrastructure Projects. The speakers are going to tackle some diverse issues, and so we're taking a slightly different approach by inviting each speaker to speak for a few minutes and then inviting any of you to add points or questions. So the first speaker is Alfred Wu. Many of you will know, partner Norton Rose Fulbright, Hong Kong, very experienced in construction and infrastructure arbitration, amongst other things. Fellow of the Chartered Institute of Arbitrators, qualified civil engineer in Ontario, Canada. I've known Alfred for many years. He has huge expertise in this area. He's going to speak about some of the developments in Hong Kong. Thank you.
Thank you, Adrian. So when I'm thinking about sort of what to talk about on this subject, and then to make sure that I'm on top of things, so I just sort of pop this topic onto a ChatGPT platform and see what comes out of it. And I've been given 3 points. One is embracing of technology. I thought a bit of a self-glorification by a chatbot. And then innovative rules and courts that are supportive of arbitration. So I thought, with my sort of 25 years of practice experience, I thought I could do better than that. So I think, in terms of innovative rules and sort of supportive courts, I think there hasn't. These are not the latest developments in Hong Kong. I think the latest development in Hong Kong is sort of like really recent development is outcome-related fee structure. So this is something that came into effect in December 2022, and it has a. I think for those of you who are interested in this subject, I mean, Hong Kong is a bit of a latecomer on this, but Hong Kong has come up with a regime that is very flexible, and it allows not just outcome related, but also, you know, the fee structure being tagged to, you know, tagged with, you know, the amount of the award of damages as well, which is, you know, not something that many jurisdictions allow. So that's the latest, and then there is sort of going back in the chronology. There is also the bilateral arrangement regarding interim measures for arbitration, you know, between Hong Kong and China, and this is something that really gives Hong Kong an advantage over other seats, when it comes to China-related arbitrations. This is because now, you know, people in sort of Hong Kong-seated arbitration can apply to the Chinese court for interim measures. These are mainly to do with the preservation of assets, preservation of evidence, and so on. And you know, for someone who is arbitrating with a counterparty who is situated in China, you know, this represents a very powerful tool in terms of, you know, being able to, you know, seek the support of the PRC court or Chinese court to, you know, to preserve assets, evidence, and so on. And then sort of further back in the chronology would be third-party funding. You know, third-party funding is something that, you know, came into effect in Hong Kong in 2019. You know, we've now had a couple of years of experience in that, and you know, this is something that is, you know, again, to bring Hong Kong in line with some of the major institutions in the region and in the world. In terms of the support of the Hong Kong court for arbitration, you know, there's nothing nothing has changed on that front. I mean, you know, if you look at all of the decisions that came out in 2022 and also the decisions that came out in 2023, Hong Kong remains a very pro-arbitration jurisdiction, and courts are very much supportive of arbitration. And when it comes to staying proceedings in favor of arbitration or upholding awards on sort of various different grounds, particularly, you know, public policy reasons, you know, these, you know, the Hong Kong court has always been sort of very supportive. I want to highlight this because I think for the last 2-3 years, there's been, you know, it's been a bit of a challenging few years for Hong Kong. And I think one needs to look at the political side of things and the commercial side of things separately. I mean, I'm not going to talk about the political side of things, of course, you know, this is not the forum for this, but on the commercial side of things, in terms of, you know, how the court operates, you know, in deciding commercial disputes and arbitration in particular, you know, Hong Kong remains, you know, the Hong Kong courts remain very supportive. It's a very sophisticated legal system. The courts are very non-corrupt, you know, very efficient, and so there is really nothing that you know, can dissuade people from sort of bringing the arbitration to Hong Kong. So those are the points I wanted to cover, Adrian.
Very good, and we're all invited to ICA in Hong Kong next year, are we?
Yeah, of course.
We'll
roll out the red carpet.
Excellent.
Yeah.
We'll take advantage of Alfred's presence before he also leaves for Barcelona. Does anyone have any points or questions they want to raise about arbitration in Hong Kong or Alfred?
I have a question. Just purely out of interest, what do you think the take-up of third-party funding has been?
You know, the third-party funders have certainly been very active in Hong Kong. You know, we have had some actually not so good experience with the funders. I hope we don't have funders in here. But I think maybe it's just the odd sort of like, you know, the luck of the draw sometimes, right? But you know, funders have always said that, you know, they're not going to second guess, you know, the decision of lawyer, or, you know, counsel representing a party. It's just that the experience that we've had is that, you know, the way they try to get involved is something more than what we have expected. And I think it hasn't been a huge take up, I don't think, because I think funders are also very cautious. Yeah, but you know, on the odd occasions where, you know, we've been successful in finding a funder, then you know, we haven't had sort of a great experience with that way. Yeah.
Thank you. That's really interesting. Thank you. Sorry, back to the floor.
And where are HKIAC's cases coming from nowadays?
Well, so if you look at the HKIAC's website, I think the HKIAC is still recording a very high number of cases. I think in 2020, I think every year seems to be a record year for them. And so, you know, 2022 is no exception. You know, we are seeing a lot of cases from sort of, I think if you look at the HKIAC statistics, you know, we have cases coming from 63 jurisdictions, you know, 93% of them are administered arbitration of international in nature, and at least one party not from Hong Kong. So it's really very diverse, right? But of course, you know, China-related arbitration sort of is still, you know, is a big chunk of that, because, you know, Chinese parties would operate, you know, in places not just in China, but they would operate in you know, in a very worldwide manner. So you know, China-related arbitration, you know, is certainly an important aspect of the cases that are administered by the HKIAC. And that's why, you know, if you know, a foreign party who is involved in an arbitration with a Chinese party, you know, Hong Kong would have an edge by reason of the sort of you know, the bilateral agreement with China, not just for the enforcement award, but, you know, in terms of interim measures.
That's excellent, Alfred. Well, look, thank you so much for being here in person, and you have a good partners conference in Barcelona, and
yeah,
had a very good return.
I think I can stay on. I think Sherina has promised to put her foot in the door to prevent the airplane from taking off.
Got that chill glass of wine ready at the airport for you, actually. Thank you very much. Great. Lucy Winnington Ingram is our next speaker, Senior Associate, Reed Smith's Global Commercial Disputes Group, advises particularly on international arbitration and particularly investment treaty arbitration and public international law. And Lucy is going to speak about the use of investment treaty arbitration in Asian infrastructure projects. Thank you very much.
Thank you. So obviously for a region that's as vast and diverse as Asia, there are lots of topics I could cover related to investment treaty arbitration. I should say at the outset that there are, of course, not even nuances, vast differences between how states approach investment treaty arbitration in Asia. But mindful of short and sweet, I'm going to focus on 2 points. So the first point relates to what I see as something of a transitional phase or approach towards investment treaty arbitration in the region. So a little bit of history. In the 1970s, there were fewer than 30 bilateral investment treaties, or BITs, entered into by Asian states. And this changed very, very quickly. And in the 1990s and early 2000s, Asian states entered into, between them, hundreds of bilateral investment treaties, many of which will be typical of the older style treaties that some of you will be familiar with. which include kind of very expansive jurisdiction protection provisions and very broad brush protections geared towards investors. So arising out of those treaties, and just as in other regions, huge damages claims, such huge damages awards for claims brought under those treaties have led to something of a backlash against ISDS in the region. So I'll give one well-known example. In 2017, the tribunal in Petit and Copper and Pakistan made an award against Pakistan of almost $6 billion, which is a very sizable portion of Pakistan's GDP, annual GDP. And at the time, that was the second highest damages award ever in an ICSID arbitration. So against that backdrop, it's hardly surprising that there's been this backlash of the right, without going into the rights and wrongs, the taxpayer is ultimately the one footing the bill for these awards. But at the same time as we've seen, this has all been going on, Asian states have also seen a massive increase in their outward foreign direct investment, which means that their own nationals are increasingly looking to these bilateral investment treaties as a means of protecting their investments in other jurisdictions. So states have a kind of tricky balance to compete for these competing considerations, and they have to kind of employ a balancing act. So what have we seen in Asia in response? We've seen some states taking steps to terminate their BITs. India, prime example, it's issued termination notices to more than 80% of its BIT counterparts. And that's further to an adverse decision in white industries and India. And in 2015, it had published a much narrower model bilateral investment treaty from which all of its future, the idea being that all of its future bilateral investment treaties would kind of proceed from that template. We've seen other states threatening to do the same, Indonesia, another example. So some states haven't gone quite so far, but what they've decided to do is not enter into any new bilateral investment treaties. And we've definitely seen a general decline in the number of new BITs in the region over the past decade. Then kind of moving away from BITs, we've also seen a move towards entering into modernized multilateral investment treaties, kind of regional treaties. And some of these provide for investment treaty arbitration, ISDS, and some of them don't at all. So to give one example, we have the bit of a mouthful, Comprehensive and Progressive Agreement for Trans-Pacific Partnership, or the CPTPP, which was signed in 2018. And this is essentially a revival of the much beleaguered Trans-Pacific Partnership after the US pulled out of that agreement. And that does provide for ISDS. It mirrors the provisions in the Trans-Pacific Partnership Agreement. But then we also have the Regional Comprehensive Economic Partnership, or RCEP. And this is actually the world's largest free trade agreement. It's the first multilateral agreement that China's agreed to be part of. And it covers 30% of the world's population. But interestingly, the current version of that doesn't actually provide for ISDS at all. The dispute settlement mechanism is reliant on the state where the investor is from kind of escalating that dispute, although there are provisions for negotiations on ISDS provisions in the future. So kind of drawing that together, what does that mean for investors and investment treaty arbitration in the region? Well, I think obviously we're going to be seeing claims coming out of new treaties, so the CPTPP, more claims coming out of ASEAN, which is an older multilateral treaty. I think we're going to be seeing new generations of BITs based on kind of state-friendly model BITs. And these are likely to rein in some of those more expansive protections we see in the older models, and also place stricter limits on jurisdiction. I think also as states look to kind of rebalance the investment landscape, we could also see some new treaties that actually impose obligations on investors, perhaps provide for counterclaims in areas like environmental damage. So that was the kind of first trend I wanted to pick up on. The second relates to the types of disputes that I think we're going to be seeing coming out of the region over the next, say, 5-10 years. Obviously, the obvious one is Belt and Road disputes. So the Belt and Road dispute aims to strengthen infrastructure, trade and investment, and it spans more than 140 countries. that account collectively for over 30% of GDP, global GDP, and 60% of the world's population. So obviously this is an initiative that's going to give rise to these types of disputes. And we've actually already seen a number of those disputes. Interestingly, those disputes have actually given rise to some pretty unique issues that tribunals have had to grapple with. So the first one is claims brought by Chinese state-owned entities. Now, typically, state-owned entities can't actually bring claims sometimes under the Exit Convention because they are not a national of a state. They are, in fact, the state. So tribunals have had to consider whether those particular entities can be claimants, whether they are exercising state authority and having entered into the agreement, or whether they are, in fact, a commercial counterparty that just happens to be state-owned. We've also seen particular issues arising out of Chinese bilateral investment treaties, many of which are what we call first and second generation BITs signed in the 80s and 90s. Some of them only allow for investors to bring claims for the amount of compensation for expropriation. So we now have a divergence of jurisprudence on what that means. Some tribunals have held that the jurisdiction of the tribunal only expands to determining the amount of compensation once a domestic court has determined that there has been an expropriation. So essentially an investor is forced to go to the domestic court in China to determine whether China has expropriated their investment. So not necessarily a particularly attractive option for investors. So that's kind of the first area, Belt and Road. The second area, growth area I see disputes coming out of is renewables, investments in the renewable sector. These types of disputes are not new. They actually account for the lion's share of claims against European states over the past 5 years, certainly. And I think that we're going to start to see that move in Asia as well. So, as of 2021, the Asia Pacific region, that accounted for almost 80% of global coal consumption. But that is all changing now. And Asian states have really kind of drilled down on their commitment towards climate change and cooperation. So just a few examples, India has announced a decarbonisation plan to achieve net zero by 2070. Indonesia and Vietnam have secured partnerships, mobilizing public and private investment to achieve their respective net zero goals. And China and the US have also recently resumed their cooperation on climate change. Now, in addition to making these commitments, in order to actually achieve them, countries in the region are going to have to start taking real steps. This will include things like stopping the construction and financing of new coal plants, retiring or repurposing existing plants early, and also huge investment in renewables projects and infrastructure. So in terms of that investment, in the first half of 2022, China was actually the world's largest solar market. It invested $41 billion in solar energy, and Japan was the third largest at $3.9 billion. And now all of this, both kind of stopping or putting an end to existing projects in non-renewable energy and investing in renewable energy, this is really fertile breeding ground for investment treaty disputes. And actually Japan has already now seen its first ever investment treaty arbitration claim over cuts to renewable energy subsidies. So very much the same kind of basis for a claim as all of the claims we've seen against Spain and Germany over the past 5 years. So that's kind of a whistle-stop tour of two trends.
It's a fantastic roundup, which I found absolutely fascinating, and you covered in your 7 minutes. So fantastic ground. Would anyone like to ask Lucy any questions or make any points in relation to ISDS in Asia?
I would like to add something.
Yes, please.
That's true. I mean, the entire trend of increasing investor state disputes and treaty arbitrations in Asia have also resulted in increasing the use of sophisticated models for calculation of compensation, and some very high value claims that we've seen, more than $5 billion, involve use of income approach, which traditionally the arbitrators have rejected because they found it remote, subjective, speculative. but with relevant contemporaneous evidences that have been used in some of these treaty arbitrations, the principle of whether to use the date of assessment and the date of expropriation or the date of award. Some of these principles have been very well exploited by the councils, especially when they're claiming or when they're pleading for unlawful expropriations. Well, as long as they are supported with relevant contemporaneous evidences of very credible, reliable, reasonable business plans and but for scenarios, tribunals have not shied away in giving those awards in billions of dollars. So just wanted to echo and second your opinion on that. Thanks.
No, if I may just pick up on that, you're absolutely right. I mean, I think I mentioned the Tepi and Copper case from 2017, where the award was $6 billion, and that was then the second highest ever award. Go back 5 years to 2012, you've got the Occidental case, where the award was, I think, something like $2.9 billion, and that was then the highest. So over 5 years, you see that drastic leap.
So the environmental pressures amongst the pressures that are creating dissatisfaction with the process.
Yeah, absolutely, yeah.
Fascinating. Well, Lucy, thank you so much. That was really interesting. And Mrinal, who asked the question, is now our third guest speaker. Mrinal Jain is Managing Director and he leads Secretariat International's Economic Damages and Valuation Practice in India. He is recognized as one of the leading expert witnesses in his field. His CV's on the link in the program, fascinating CV. Thank you so much for bringing an expert perspective. So you're talking about future trends in damages and claims in arbitration involving Asia-related infrastructure projects. From your perspective, please. Thank you.
Thank you, Adrian. I feel I'm the odd man out here, providing an economic and financial perspective on the future trends in Asia, particularly India. What's exciting to know is the infrastructure sector has been by far the most contentious in Asia, and it's going to continue to be so for the next decade. I mean, just to give you figures, India alone, government of India has just recently released that they would be investing USD $1.275 trillion of investment in the infrastructure sector in India in the next 5 years. So we definitely see a lot of disputes, a lot of contractual disputes, as well as investor state disputes coming out of this investment over the next 5 years. So sector-wise, it's energy, it's roads, it's railways, it's urban, it's real estate construction. These are some of the subsectors where we see massive amount of disputes emanating from this investment that has happened in the last 5 years and going forward as well. Second, moving on to the sort of key changes that India has witnessed. We obviously see a lot of institutional arbitrations happening. It's LCIA, SIAC, ICC, MCIA. Sherina was talking about multiple institutes that have penetrated India further, and they've done a phenomenal job. Traditionally, India was relying more on the ad hoc arbitration cases, and now increasingly it's becoming more institutionalized. What and how does this help? Obviously more efficient, and for experts like us, this gives an increasing opportunity because the tribunals and the councils are increasingly using and understanding and appreciating more than anything else the role of independent damages experts in assisting, as long as the experts are clear that our duty lies towards the tribunal, in assisting them on some of these technical issues related to damages, whether there are complex economic, financial, accounting, and or valuation issues. So we definitely see a trend where increasingly our role has been phenomenal, important, relevant, as long as the liabilities have been proven. We work with the councils in assisting the tribunal in arriving at an unbiased figure of the claim where they need our expertise on. Moving on to types of damages, claims, and losses that we see in infrastructure disputes. Well, broadly, we can categorize them into reliance versus expectation. I'm not going into the legalities of that because I'm sure all of you are experts in that. But what it means for a country like India and more in general for Asia is when we talk about reliance damages or wasted cost or hard cost as the third-party funders call it, they're primarily the investment that has been done by the claimants by relying on the contract, the costs that have been incurred once they entered into the contract. And this has by far traditionally been a very popular head of claim amongst the arbitrators. Why? Obviously, because these are costs already incurred historically. There is almost always going to be some sort of evidence to substantiate these costs, either in the form of audited financial statements or invoices or bank statements. The question is, and the recent trend that we're seeing in very high value, large, complex infrastructure projects, tribunals are not satisfied with the audited financial statements. Also because there may be some cost allocation issues, there may be an overlap, the question of fixed versus variable costs. And over there, we've seen that tribunals are expecting more out of the experts from the councils, from the parties involved. So they normally divide the entire verification of wasted cost into 3 layers. One is just simply relying on historical financial statements. Step 2, if there are cost allocation issues, they are expecting parties to substantiate and their respective experts to substantiate the liability by looking at evidences such as invoices, purchase orders. And one step going further, in some of the cases, they're also expecting that out of the total quantum of liability, how much is paid out by the claimants, in which case we move on to evidences like the bank statements and the payment receipts. So sometimes in these large infrastructure, complex projects, the councils instruct us to go through all 3 phases, which is, by the way, sometimes even more rigorous than what auditors do for their companies. But we need to go through that process to convince the tribunal that this is the quantum of liability and this is the portion of that out of that quantum which is actually being paid out. Then moving on to the alternate head of claim, which is expectation damages or losses. That has been a tricky one. Traditionally, India and some of these jurisdictions haven't accepted loss of profit as a head of claim, haven't been awarded enough. There have been exceptions made in the past, but not a very popular head of claim. Reason? Tribunals consider that as remote, speculative, subjective. There's an element of uncertainty involved because we're talking about future, we're talking about future cash flows. And a lot of these infrastructure projects, they are primarily public-private partnership agreements, long-term concession agreements going over 30, 35 years, where the dispute happens in the initial 5 years. So the question then comes whether the investor is entitled to claim loss of future profits over the remaining 25 years. The trend that we are seeing now is increasingly arbitrators are accepting loss of profit claim. At least they are ready to hear out the party's position on what that potential loss of profit claim would be. The challenge comes in most of these agreements or contracts. There's almost always an exclusionary clause, a clause that could prohibit either party from claiming any consequential or indirect losses in the nature of loss of profits. But having said that, we've still seen councils instructing us to calculate these loss of profit cases because their pleaded position is that these losses are directly emanating from the breaches and the alleged wrongful actions of the counterparty. So therefore, the burden then transfers on us as economists and financial experts to ensure that we address the elements of causation and mitigation in an economic and financial sense, to ensure when we do the modeling, when we do the calculation, the losses should be clearly attributable to the breaches, to the alleged wrongful actions of the counterparty. And that's where I think it's very important that experts should be aligned with the council's pleaded position in case there's an exclusionary law. I mean, this is true even under English law. There are several cases where we are LCIA or ICC under English law where we see exclusionary clauses, limitation liability clauses, but there are several exceptions to those clauses. In cases of fraud, misrepresentation, we've seen councils taking a very aggressive position that because of these exceptions, we can still claim some of these loss of profit cases.
Gross negligence.
Exactly, that's the word I'm looking for. Thank you, Adrian. Thank you so much. So that's a trend that we're seeing in Asia, particularly in India, increasing use of loss of profit as an alternate head of claim, increasing use of discounted cash flow method under the income approach to calculate these loss of profit claim. Again, some of the statistics that we've done research based on that, it shows that increasingly experts are using discounted cash flow method as one of the preferred methods to calculate these loss of profits. And the arbitrators are accepting that as long as we present a reliable, robust, credible but-for scenario or the counterfactual scenario. I think everything boils down to the contemporaneous evidence and how effectively we can convince the tribunal that the assumption there are reliable. One last point on the use of technology. Yes, it has also affected experts. Increasingly in India, where we see most of the clients that are cost effective, who are looking for some savings, are still going for a hybrid model where its cross-examinations are happening virtually despite everything being opening up. So we definitely foresee that the use of technology is going to continue in India, in Asia. There will be several virtual arbitrations. I'm currently doing an HKIC matter again, which is completely online. So that's it. I'm happy to answer questions.
Fantastic. Well, what a fascinating roundup from a particularly interesting perspective from the lawyer's point of view. Thank you, Mrinal. Would anyone like to ask Mrinal anything about his dark science? Yeah.
I had a question. It's about India and about the recently announced changes to regulation for foreigners. It may not be fair to ask them right now.
Exactly.
Probably would have been better to ask Sherina, but I shouldn't check. So I'll just raise it in case somebody else has got you. I mean, we've heard that there are to be changes. Firstly, to what extent are we clear about what those changes will be? And secondly, what is going to be the impact of those on practice by foreign lawyers in India?
It's probably an unfair question from Mrinal. I know Sherina was mentioning this at the outset, and I think there's some uncertainty while people examine, what the new regulations say and what the effect might be. Do you have any? Given that she's a colleague, and I asked her whether they're going to set up an office in India.
No, we haven't been able to, set up an office in India. I think that this idea has been been toying with this idea back for a number of years, but we haven't actually done that.
I think Sherina could tell you best if you catch her, over the weekend at some stage. But it's probably dangerous for us at this early stage to don't know enough about.
I can try. Sorry, I can just try and address it from a non-legal perspective because I work with a lot of Singapore and UK councils. What I can definitely say is that a lot of those regulations are very ambiguous right now. The clarifications that have come out over the last 7 days, again, do not address all the aspects. For example, somebody like Sherina, who's done phenomenal work in the India market. If Norton chooses not to set up an office in India, how does it impact their 90-day or 60-day fly-in out policy, right? Because that restriction has come down, in fact. Overall, it's a very positive move because obviously you are allowing foreign firms to come practice foreign law in India. I think the ambiguity currently lies in terms of what are the administrative procedures in terms of getting that registration done, whether they would be allowed to do advisory work and to what extent. If firms choose not to have an office, because every firm might not want to have an office there, then what is the policy applicable to them? I think the dust needs to get settled. It's definitely a positive move, but I think within a quarter, we'll have much more clarity. I mean, that's all I can add as a non-legal.
Well, I think it's very helpful. Leave it on the non-legal basis. Great. Mrinal, thank you so much for giving us the benefit of your expertise. That was extremely interesting. Thank you. So, fourth speaker, home speaker, even though she is speaking from New Mexico, Swee Tan. She's a member of Chambers. She's an international arbitrator member of Chambers. She's based in Kuala Lumpur as well as in the US. She's a construction, infrastructure and energy expert, and she is a full-time independent neutral, taking appointments as arbitrator, adjudicator, dispute panel member. And let me hand over to you, Swee. Thank you. You've chosen a comfortable time of day for you in New Mexico, as opposed to poor Kevin. Please introduce your subject.
Thank you very much, Adrian. You're indeed correct about it being a much more comfortable time. I flew over here from Kuala Lumpur just in order to be in a much more comfortable time zone. You know, we did this sort of seminar in Chambers in January 2020, just before we had a very, very hard lockdown in Malaysia. And I was hoping to be in Chambers in person to as a coming out party, so to speak, post-COVID. But that wasn't to be, and I said to Johan that I wanted to appear as a hologram, and then he promptly told me that's so yesterday, Swee. So on Zoom instead. Good evening, everybody, and thank you very much for being here with us. As Adrian says, I'm dialing in from New Mexico, where in the US, where I spend some of my time. I was going to change tack a little bit. I didn't want to talk very much about sort of innovations of regulations and of laws in Malaysia, because as Adrian mentioned earlier on, Dato' Sundaraju has just taken over the helm, retaken the helm of the Asian International Arbitration Center in Kuala Lumpur. And with his reputation of rapid innovations, I didn't want to be talking about that now, only to be outdated within a month or two. So really what I wanted to do was actually to start talking about what's going on the ground in terms of arbitrations, especially in infrastructure arbitrations in Asia, and to try actually just get under the skin a little bit of what's going on. So the first thing I wanted to talk about is actually this big blur between the line of domestic and international arbitration. Now, I realize that, I mean, we always talk about international arbitration. We talk about ourselves as International Arbitration Council or arbitrators. And quite often, I mean, the domestic matters may be relegated to juniors as everybody chases all that sort of internationality. It looks great on LinkedIn, for example. And of course, I mean, for us arbitrators, the higher scale of arbitrator fees in US dollars is always some attraction. But I wanted to actually talk about this because I would say that if we ignore this aspect, we ignore it at our own peril. Given the way that the construction market has been going on in Asia, you find that actually there are a lot of domestic arbitrations, and high value ones at that, are in reality international arbitrations. Why do I say that? Because most of these construction projects or infrastructure projects are undertaken by, let's say, a locally incorporated developer or sponsor, quite often the government or a state-owned enterprise, but that the contractor, although locally incorporated, is nothing more than a subsidiary or a branch of a foreign company. Now, China, I think, is a very, very good example, as has been mentioned by Alfred and by other colleagues, because they are contractors in many, many jurisdictions. They are really all over the place. And if I take my home jurisdiction of Malaysia as an example, you may find that the headline main contractor may be a Malaysian company, but very, very substantial subcontractors are in fact Chinese companies. But when it comes to the actual arbitration or any form of dispute, it will be a Malaysian subsidiary against, let's say, a Malaysian main contractor, which immediately then brings it within the realm of domestic arbitration and with all the pitfalls, if you want to call it, of that. But in reality, we are actually dealing with a Chinese entity whereby all the instructions are coming out of head office, and you have to manage it accordingly. Now, this is to be contrasted against, for example, a British or UK subsidiary operating in Malaysia, and we've had plenty of those as well. And it doesn't have to be Malaysia, I mean, it can be anywhere in Asia. You find that the difference there, for example, is the fact that the UK subsidiary is often given a lot more autonomy in how they manage their arbitrations. The reason I bring this up is because as lawyers on the ground, in trying to make your arbitration and manage arbitration in a very successful manner to get the result that you're looking for, you're really having to manage the people on the ground, your project teams, and how do you deal with that if you don't really know how they operate from the inside. So if this is just getting a little bit of an insight as to what's going on the ground here. The fact that somebody is working locally, I mean, doesn't necessarily mean that they understand the local environment. I mean, I'm sounding like a sort of HSBC tagline here, you know, foreign bank working locally. And there's a large element of we always do it like this. And it's bad enough with the local context, but it's even worse when this kind of like exported from your home jurisdiction to a foreign jurisdiction. Asia is huge, it's multilingual. Mrinal will tell you in itself that India in itself has got so many different languages. Who from where matters. If you just talk about food, that in itself is going to tell you about the great divergences of regional differences, you know, from north to south of India, from Sichuan to Cantonese, from the Malay to the Chinese communities in Malaysia. What I'm going to conclude this point with is to say that communication and client management is such a key ingredient to success. Why do you think my colleague Adrian, as a Caucasian, is so successful operating in China? Because he's got that key ingredient. You know, I did an ICC interview recently about diversity, and we talked about diversity just now in panel number 1. And you have to actually think about it in these terms. A Chinese arbitrator being appointed in China isn't diverse. A Caucasian arbitrator being appointed in Hong Kong is not necessarily diverse either. So, you know, there's so many layers to this, so many layers of an onion skin. And I am going to suggest to you that often documents do not tell the whole story if you're dealing with arbitrations in China and in India and in Korea. And all those jurisdictions are large and they are actually very, very different. I think Hong Kong is a unique one, as is Singapore and Malaysia, and each of them have to be dealt with its own appropriate sensitivity, shall I say. I'm going to use an anecdotal example about getting under the skin about communication. One of the last few cases I handled, last few larger cases I handled as counsel was in respect of a coal-fired power plant in Malaysia. And we didn't go into arbitration as it turned out because we had 2 rounds of one statutory adjudication, another contractual adjudication, and that ended up with a settlement. The communication there was just so important because we were dealing, our client was a Chinese SOE. And intelligent and well-informed as the team was, extracting the information is not the same way as you extract information from, let's say, a more Western set of project team. When you ask a question of a nation, you tend to get a short, direct answer. Now, my late father used to say that sometimes it's like a typewriter. If you hit an A, you get an A. If you don't hit the A, you don't get an A. If you don't hit a key, you don't get anything. So you're not going to ask an open-ended question and get a long story. So what you're going to do here is that you're going to ask a question, you're going to get the answer, but that answer doesn't tell you enough. So what we did in the end was that we actually embedded one of our young lawyers who was a native Mandarin speaker into the team. And they were just chit-chatting, and a lot of information came up from the chit-chat that you couldn't extract from either the documents or actually just from what we might traditionally call client interviews or witness interviews. So these are the sort of things that I think that you really have to be alive to if you're going to be successful in doing arbitrations in Asia. And the future trend is that you are going to be doing arbitrations in Asia. Let me quickly just go the total opposite, which is that where an international arbitration is actually domestic. Malaysia is a great investor in places like Cambodia and Singapore and in places like Vietnam. And a recent example would be that this wasn't so much an infrastructure project granted, but it could happen equally. This was a Malaysian developer developing something in Cambodia. They then had a Malaysian contractor doing that work with a Malaysian consultant team. And guess what? They used a Malaysian standard form of contract. Now, all the parties involved were Cambodian insofar as they were locally incorporated subsidiaries. But in reality, this was not much more than a Malaysian arbitration. The same can be said of other countries as well. Now, when we start to expand all this, road concessions in Pakistan and India, then your realm of what you have to deal with becomes more and more, and it is, like I said, just layers of the onion skin. I wanted to just quickly touch also on the issue of natural justice within the concept of Asian arbitrations, because natural justice for me, sitting as a neutral, is something that I've got to be very, very aware of. And what people consider to be natural justice and what really is are some things that you have to think about. Let's start off with the fact of, we talked about AI and the access to that. AI in terms of, for example, word searches, document searches that are so available to the larger firms like, you know, before us today, Norton, and Reed Smith, and the secretariats of this world. But you also may find that there's a lot of very, very competent local Asian law firms who are very, very good at what they do, but may not be as large as international to enable them to purchase or embrace AI to the same extent. Now, this puts them actually at in a way, a disadvantage, and they may actually apply to the tribunal to say that they need more time to be able to put together the bundles. And if you're going to be short and sweet, as what panel one was talking about, well, do you actually then have to apply the same rules? Do you give them the same considerations? Do you give them extra consideration? Is this or is it not a breach of natural justice? I mean, we can go on and on about this, and I know that we don't have enough time for this. But before I conclude, I just wanted to also talk about the fact that there are different attitudes to contract management and to arbitration hearings. Now, I know that contract management in terms of infrastructure projects are not great around the world, but from an Asian perspective, again, what I said about documents not telling the whole story, I think that's particularly true because you take notices as condition precedents. I think that you often find that a lot of Asian parties are quite adverse to notices because they may see them as actually kind of rude to be giving them, a little bit sort of confrontational. And yet that, of course, is often a condition precedent and often raised as a defense. As a neutral, I have to consider this fact. I mean, the easy thing, of course, is to simply say that, oh, the conditions precedent have not been met, claim dismissed. But you also have to balance that up against the fact that is this actually being taken advantage? Are they being taken advantage of? And is it a party that's able to take advantage of their own wrong and benefit from that? I give you no answers to these issues that I've raised, but I'd like to actually ask you all in the audience to have a think about what it's like to be arbitrating and handling matters in Asia. People like Mrinal and Alfred and myself, it's a little bit easier because I mean, we grew up there, we're educated overseas. So we have kind of like insight to both sides of the coin. Something that Adrian, I think, is an unusual one because he has actually managed to get in to the market in Asia, and it actually got into the head of the Asians. Like I said, the onion skin, yeah, the Western sense of logic of little boxes and compartmentalizing it is not that applicable in the Asian market. and certainly not the Asian mind. So may I leave you with that thought and say thank you for being part of all of this, and thank you for listening.
Swee, thank you so much for giving us some practical thoughts about arbitration in Asia, and for being the mastermind with Matthew for this second seminar. So thanks very much for your organization and for joining us from exotic New Mexico. Well, the principle of family hold back when you have a sort of dinner on a Sunday and you invite lots of people and there's very little left. I had, of course, a lengthy talk to add as speaker number 5, but there's wine chilling at the back, and you've all been extremely patient. All I would say on China in conclusion is that during COVID, quite a lot has been happening on the arbitration front with the proposed revision of the arbitration law and the introduction of ad hoc arbitration and the ability of tribunals to order interim measures. The establishment of an international commercial dispute prevention and settlement organization, sort of overarching one-stop shop, which has just issued its arbitration rules. It's really a question of wait and see as to how arbitration is developing in China, how Chinese parties will be approaching arbitration in the future, particularly SOE parties, for example. At the moment, one still sees Chinese SOE parties arbitrating all over the world in the main institutions. Their projects in nearly every jurisdiction, and their arbitration, my most recent experience was Stockholm, where it all started, but ICC, LCIA, and SIAC. We posed questions, challenge and opportunity. I think we had a lot of cooperation with China over the last 30 years, the training schemes run by our Bar Council and Law Society, and cooperation with CTAC, the Arbitration Commission, and through the Great Britain China Centre, judicial exchanges and arbitration exchanges. Those have suffered during COVID, but also because of the geopolitical situation and the fact that, for example, GBCC's funding was cut 2 years ago, and they've had to work very hard to reinstate, so that an arbitration project that I was involved in between the UK and the China University of Political Science and Law was incredibly productive and played an influential role in the revision of the arbitration law. That sort of cooperation is threatened if the respective institutions are not funded and encouraged. But I think on the professional and arbitration level, it's very important for us to foster relations with our opposite numbers in different countries, including China. And I was encouraged when Johan returned from Dubai to say that there were a lot of arbitration lawyers from China who came out now that people can move more freely. And one hopes that post-COVID that we cut through the politics and that we re-establish our contacts and friendship. It's particularly important, and it's a particular opportunity in international arbitration for us to have those relationships with our peers. It's a bit like Antarctica. I used to be in the Navy, and I spent a year around Antarctica, and we would fly into different bases to inspect the bases under the Antarctic Treaty. It was during the Cold War, when there was no other opportunity to meet Russians, Chinese, or Eastern Europeans. And it was one part of the world where everyone prided themselves on having no political problem, and they had shared hardships, and that encouraged friendships. So I hope that the international arbitration community that we can move forward on that basis and come to Hong Kong with Vika next year.
Yes.
And so let me conclude by thanking very much the session 2 speakers for coming along in person and virtually, Swee, The range of subject matter and expertise has been absolutely terrific. I hope that we're very grateful to you for turning out in the rain, in person. I know a lot of people are watching this webinar virtually and have not made that effort, but it's terrific that you all came and supported the event. And I'm sure you'll agree with me that we've been treated to a wide range of interest and expertise. So